Appeals of Tennessee is now in session.
Thank you, Mr. Clerk. Good morning to the attorneys and the parties in this case. Your panel this morning is consisting of myself, Judge McClarty, Judge Golden, and Judge Davis. These proceedings will be conducted as if we were actually in court, except you will not have to stand when you make your presentation. I would, however, let you know if there is any technical matters that develop during these proceedings, please let us know immediately so those can be taken care of. I understand that the parties have already reserved their time for rebuttal. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
Okay. In that case, Mr. Clerk, if there's no preliminary matters, will you call the case that's set at 10:30, please?
Severiano, Martinez, Rubio et al. Versus BB&J Holdings et al.
Thank you. For the appellant, you may present your case.
Your Honor, if it pleases the court, my name is Betsy Stibler from the Hamlin County Bar, and I represent the Rubios, the appellants in this matter.
Yes, ma'am.
I assume that you are familiar with the facts of the case. And what we are here to present to the court today is a question about the application of law in the trial court. There was a piece of property in a residentially restricted neighborhood that was purchased by the developers. The house was removed from that piece of property, and the piece of property was used to connect the road that goes through the neighborhood that the Rubios live in to their commercial development that sits on what was previously farmland behind the Rubio's home. This roadway is directly adjacent to the Rubio's home, and the trial court found that that roadway did in fact violate the restrictive covenants of the subdivision, which stated that the subdivision could only be used for residential purposes. Just like in several cases, Laughlin v. Wagner, Lane v. Taylor, they attempted to remove the restrictions by rezoning, which of course did not remove the restrictions, and use that property in derogation of the restrictive covenants. It is the appellant's position that when the court found that the restrictive covenants were violated, that the proper remedy was equitable remedy for an injunction prohibiting the use of that roadway as a entrance and exit into the commercial development. That was
Now, it's my understanding that at that point, when the actual petition was filed, then the road had been completed and was in actual use. Is that correct?
That is not exactly correct, Your Honor.
That's not correct. Okay.
The roadway, as it was constructed, the commercial property was in use when the petition was filed. The biggest issue with speaking to the roadway during construction for the Rubios was the fact that they went down to the city center. They spoke to the assistant city administrator, who informed them that that roadway could be built, and that they spoke with Mr. Bunch, the lead developer, who said that the roadway could be built. So as far as the timing of that petition was concerned, it happened right around the same time as the roadway was completed, and it had been used over the last several months to move things in and out of that commercial development.
Okay. Mm-hmm.
Yeah. So that is the lead issue for this court as far as where we sit with this roadway. Using looking at the city's brief and the developer's brief, they seem to misunderstand what it means to be completely encapsulated by commercial development, such as in Heisinger v. Mullinax. This development on the upper end, for visual purposes, if you think about it as a T, the upper end is Andrew Johnson Highway. There are a couple of commercial businesses there, and the developers of those commercial businesses sought and received a release of those restrictive covenants in 1999 in order to front Andrew Johnson Highway. The interesting aspect of that is that that work was completed by the city attorney, the city attorney's office, one of the partners in there who was considered to be the city attorney for all real estate matters. That same attorney represented the developers in this development. And it has been the Rubio's argument all along that they knew well that this was restricted covenant, that this was a restrictive covenant, that those attorneys and had gone through and received a release of those restrictions in order to develop those two specific properties, and that the restrictions remained in place for the rest of the neighborhood. Where we believe the trial court erred is in allowing the changed circumstance that the trial court relied upon for its denial of equitable relief. That changed circumstance was actually created by BB&J in this development, that prior to this very large development, that was farmland. And the Rubio's backyard was a tree line. There was not constant 24/7 traffic beside their home. It was, in fact, still an intact farmland behind them. And that is the purpose of restrictive covenants, to prevent that encroachment. We have in 1999. Yes.
I'm sorry, just to make sure that I understand it. The commercial development that I think the defendants are saying defines the character of the area as more commercial than residential at this point, that was already there, right? The only thing that was added that is the basis of this lawsuit was a road for ingress and egress. Is that correct?
That's not entirely correct.
Okay.
So the way that if we go back to my T analogy, and the road that we're talking about, the neighborhood road, is the straight line of the T. Over behind the neighborhood on the left side, there was a commercial development that had been there since probably the 50s. It's changed tenants over time, but it has remained. On the other side of that T is the Rubio's property, and behind that property was residential neighborhood. Now, if you make a bottom with an I, there's a road that crosses parallel below. That is all still residential neighborhood. So what has changed? The only thing that has changed is that road through the piece of property where they remove the house to create that secondary ingress and egress, and the commercial development that it services. Just so the court knows, there are two entrances to that commercial development on Andrew Johnson Highway. And so there's not a need. If this road were not there, people could still access it the same way that you would access anything on and off of a highway. What they did is they created this secondary, they call it a secondary, but it's actually a third ingress and egress in order to please their tenant, who wanted, what the quote was access to more rooftops to make it more convenient for them to pull into the shopping center. And in doing so, they completely changed this neighborhood. It is now a thoroughfare to a grocery store and a shopping center, where before it serviced all the rest of the lower part of the neighborhood for people to go to the main road, and then, which is Andrew Johnson Highway, and then go from there to whatever business, commercial activity they desired to. And so what you have now is what had been previously protected from that encroachment being completely bisected by it. And so the Rubios always believed that they should have sought a release of those restrictive covenants. The attorneys for the development knew there were restrictive covenants. There was testimony at trial that Mr. Bunch knew that there were restrictive covenants, and they just forged ahead because they wanted that roadway. And in doing so, they have changed the neighborhood.
The remedy that you were seeking in the trial court, is that remedy injunctive relief for prohibit them from using that roadway and damages, or just injunctive relief? Which one or both?
So, Your Honor, when we first filed it, we were looking for possibly a nuisance claim under the restrictive covenants. But restrictive covenants are grounded in contract law, and we believe that according to the contract and the restrictive covenants, that injunctive relief is proper. And that continuing to allow that roadway to be used the way that it is, instead of being restored the way to the condition it was prior, which is residential only use, is the proper remedy under law, and a long line of cases and precedent from the state Supreme Court all the way to the Eastern District Court of Appeals.
Okay. Thank you very much. You have time for your rebuttal.
Thank you.
We'll hear from the appellee at this point.
Your Honors, I'm Eric Harrison. I represent BB&J in this case, the developers. I'm also with the Hamlin County Bar. It pleases the court, I want to address just a couple of things that Ms. Stibler brought up before I get into the crux of my argument. One is, she mentioned the fact that there were two entrances on AJ Highway already, and that this third entrance was really not needed per what the developer had promised the tenants or so forth. If the court looks at the record, that's actually, it is correct that there is a way to get out onto Andrew Johnson Highway, the main ingress egress for this development. There is a separate way to do it, but the testimony is that it's about 500 feet up from the original main entrance to this development. The problem was, it wasn't just the tenants, but the testimony in the record shows that it was actually the city that had also required it because of the traffic impact study, which sort of dovetails into another part of the argument having to do with the nature and character of this overall area around this subdivision. So the reason they needed a separate ingress egress was because there was somewhere in the neighborhood of 38,000 cars a day that went down Andrew Johnson Highway east-west in front of the development. So even though they had a separate sort of circuitous way to get out of that subdivision or out of the development, it dumped out right near where the original ingress egress is for that development. In other words, it didn't solve the problem. It actually would have made the problem worse by having two different ingress egress within a few hundred feet of each other dumping out on AJ Highway. So that's why the city actually wanted them to have a separate ingress egress that didn't come out onto Andrew Johnson Highway, which again, the nature and character of this subdivision is so different than when it started. If the court please, the Rubios in the traffic impact study that's in the record, there were over 6,000 cars a day that drove the north-south Walters Drive right by the Rubio's house, right in front of them. Their houses are pretty close. The court sees the pictures, are pretty close to the roadway there. So at the time this original subdivision was developed, it was actually a country area. It wasn't in the city limits of Morristown. It was in 1951. So talking 60 years prior to the time that this subdivision was made, when you fast forward to when this development started. I think that to say that somehow the BB&J caused the nature and character of the area around this development to change dramatically is not accurate. There were multiple businesses. The Plaza Shopping Center on the east side of the Sunset Edition where the Rubios lived. There was a convenient mart on the north side. There was a multi-family residential unit put in behind the Rubios, sort of the northwest corner of that area. There was a Blockbuster Video. There was a Weigel's. There was a CVS, which, by the way, all took lots from that subdivision and were all commercial developments prior to this this development being being created and constructed. So the truth of the matter is, when you fast forward 60 years, the testimony was that this particular intersection, which the Rubios can actually see from their front yard, they can walk right out and look up the hill. It's only a few hundred feet away, is one of the busiest intersections in Morristown. It's like I say, 38,000 cars a day, according to the traffic impact studies. There were several.
I'm sorry
Yes.
to interrupt you, but
Yes.
the existing commercial development that's built on what used to be residential lots, that was obtained because the developer went through the process and got a release of the restrictive covenant. Why did your client not do that in this case? I mean, it kind of seems like they said, we're just going to build this road and that's just the way it's going to be.
Well, it's not exactly clear what Ms. Stibler alluded to having to do with the city attorney and his law firm. So Ron Perkins was the attorney who handled the development of the CVS and the plot and the Blockbuster and all that. Those are the ones that about 10, 12 years prior to this development being begun, about that time period, Ron Perkins is the one that helped, actually not this particular developer, it was a different developer, by the way, to build the CVS, the Weigels, the Blockbuster, all of those that took several of those lots on the south end of the subdivision there. So he was law partners with Dick Jesse, who was city attorney at the time. So by the time we got into this case, Ron Perkins had passed away. We don't really know why they did it that way the first time or the second time. We can speculate. And the fact is that most of the commercial leases, as the testimony was, commercial are about 50 years, are restrictive covenants, are usually time limited. Mr. Bunch testified that he's done numerous residential and commercial developments. Typically a 50-year restrictive covenant limit is on commercial, and that's what's on the Massengill Springs in this case. But residential's typically 20 to 25 years. So it's not really clear why, other than to speculate, perhaps Mr. Perkins felt that at 60 years, it's beyond any usual and customary length of time for a restrictive covenant to be in place, which also brings up the issue of waiver and estoppel because in this case, the Rubios were aware that the road was being built. They talked to Mr. Bunch. He went to them, explained to them what was being built there, and discussed this with them. That if they had had an objection, they certainly didn't voice it to him, and they had an opportunity to file for an injunction. They could have taken it up with the city. I think their testimony was that they went to somebody at the city and spoke to them, but there was never any verification on what discussions were had, who they spoke to, or anything along those lines. So really, in the record, there's no proof that they made any sort of an objection. They certainly didn't file for an injunction, which they could have done to have made this issue, brought this issue to light had that happened. And to be fair, even had they done so, I feel like we would have had the same result. You still have it's just not equitable under the circumstances to enforce these restrictive covenants. These particular restrictive covenants, as Mr. Bunch testified to, he said, yes, I knew they were there, but two problems. One, the original restrictive covenants restricted non-whites from owning property in that subdivision, and he knew that. And his calculus was, well, we're talking about 60-year-old restrictive covenants. Heck, even it was such that non-whites couldn't even buy in here at that time. Those can't really be enforceable at this point. And the second being that, according to the city, they needed this separate ingress and egress. And while those restrictive covenants were in place, Mr. Bunch felt because they were so long in the past, and he knew from his own experience that 20 to 25 years was about as long as a residential restrictive covenant would be in place, that those wouldn't be valid anymore in any event. Keep in mind, he wasn't a party to the development of those lots up on the south end where they had gotten the waivers. Again, we're not sure why Mr. Perkins didn't go through that process a second time, other than to speculate that he didn't feel like it was necessary at that point because of the time frame that had elapsed during that 60 years of
what I'm interested in if it's in the record, what is the time period from the completion of the road that you actually received notice of injunctive relief or litigation?
It is in the record, Judge. Mr. Bunch testified, and the record showed that the road was begun in 2013, completed in early 2014. I think the record says several months later it was completed, and that by the time the petition was filed, I think in December of 2014, the roadway was already completed, had been cut, and was basically there. It was just waiting for the development for the roadway to be dedicated to the city, I guess, at that point. So it was complete at the time that this suit was filed. And that is in the record, Judge. I can't cite you book and page number just now, but I remember reading it in the trial transcript when I was reviewing this beforehand.
Thank you.
Yeah. So the other thing I want to touch on briefly in my last few minutes is the nuisance claim. The burden is on the plaintiff to prove nuisance and to prove damages. In this particular instance, the record, as the trial court correctly points out in its opinion, is that the record's really devoid of any substantive proof as to damages. So he gave a nominal $500 damage award, which we think would be appropriate under the circumstances, since he found that there was enough apparently to find that there could be a nuisance claim viable here, and he allowed the $500 nuisance. We think that's appropriate, given the fact there was no proof of loss of fair market value or anything along those lines. And I'm going to cede the rest of my time to my co-appellee, the city of Morristown, Lauren Carroll.
Was there a reservation of time for the?
Yes, Your Honor. We spoke to Mr. Hivner, and he put me at 10
Yeah.
minutes and is giving
We're
her
here
5.
We're here. Go right ahead.
Good morning, and may it please the court. I'm Lauren Carroll, and I am the city attorney in this matter. And the city, we concur with every argument that Mr. Harrison just presented to you. We believe that the trial court did appropriately apply the law to the facts in this case and made the correct decision. In the alternative, and as addressed by both Mr. Harrison and I in our briefs, we believe that this appeal should not even be considered, as the appellants have failed to comply with Rule 6 of the Tennessee Court of Appeals. Specifically, the appellants failed to cite to any erroneous action of the trial court, failed to cite to any part of the record where any alleged error was called to the attention of the trial court, did not recite where or how they were prejudiced by any alleged error. The appellants have basically made a bare assertion of error with just a general statement that the trial court was wrong, but they failed to show where or how the court was wrong. The appellants merely state that the trial court misapplied the standard in Heisinger versus Molinax, but in making their argument as to why they believe that this standard was misapplied, they don't cite to the record at all after stating what they want this court to view as facts. That's likely due to the fact that the assertions of truth that they've made are not facts. For example, when they state that this neighborhood is encapsulated in commercial development, all at the fault of BB&J, there's not a record citation supporting this because this was an untruth. They also state that no other parcel in Sunset Addition has been used for commercial purposes. Again, another untruth, no citation to the record because this was not a fact. They basically completely ignore the exhibits that were introduced at trial and are part of this record that show that this commercial development began in this area back in the 1960s. And at least 4 of the lots that are closest to the lots owned by the Rubios have been used for commercial purposes since 1999. They failed to include any citations to or really make any argument as to how they were prejudiced by the decision of the trial court. Again, just this bare assertion that the trial court was wrong. The trial court heard and considered all the evidence introduced by the appellants and gave proper consideration to such evidence when applying the law to the facts and writing its memorandum opinion. We just don't believe that they've cited enough or complied with this rule to even have the Court of Appeals consider their argument. Some of the cases that they do cite to are the exact same cases that were cited to and presented to the trial court in their motion for partial summary judgment back in 2018, which was ultimately denied. They basically made the same argument now that they made back then. Again, we just believe that they ignore the facts that were actually part of the record pertaining to this case, that no, this isn't an exclusively residential area anymore, that there is a significant change nature in this once rural subdivision to now there's houses that are located in the middle of the town and along a street that have over 6,000 cars a day that go up and down the Walters Drive road that fronts the Rubio's home. Obviously, this court does have discretion to still consider the argument, even if it, and not dismiss it just for a procedural issue. And the court's, of course, done that in the past. But again, it's our position that when the court has done that, it's been where there's been pro se litigants who haven't complied with the rules. This court has rules, and this particular rule, we believe, does apply and should not allow their argument to be considered by this court.
Thank you.
Thank you.
Anything further? Okay, you're waiving your balance of time, is that correct?
Yes, that's fine. Those 40 seconds. If there's not any questions for me on behalf of the city, then we don't need to use the remaining time. Thank you.
Thank you very much. We will hear the appellate on your rebuttal.
You need to unmute yourself.
But not.
Thank you very much. Let me just address the issue of that traffic count. If we look at that actual piece of evidence, that exhibit, it is not a traffic count in front of the Rubio's house. It is at an intersection downstream of it. And hard to know exactly which cars are headed in which direction. So I would like to first address Mr. Harrison's argument, the speculation as to why Mr. Perkins did not seek a release in this case. The record is clear that Mr. Bunch was aware of them and decided they didn't apply. The reason given was because he figured that because there was a restriction against non-white residents in the neighborhood that they would not, that they were waived, that they were unenforceable. The problem
Just
with that
because we got one restriction, it covers all? Is that what you're saying?
Yes, Your Honor.
Okay,
And
very good.
even better than that, the developers realized that in their restrictions that they recorded, that they had something that they did not want there, and turned right around the next day or within just several days later and filed a release of that restriction before parting with any lots in that subdivision. So they realized, yes.
Is this case, I think you mentioned it, but I'm not entirely clear because I haven't looked at the actual complaint, but is this pled as a nuisance claim?
Your Honor, it was pled as both a nuisance and a violation of restrictive covenants. And so as the evidence developed and as the case went on, what we argued at the partial summary judgment hearing was that these lots were restricted by covenant and that this road violated the restriction. In denying...
That's not like a breach of contract claim on the violation of restricted covenants. I'm just wondering what the cause of action is. And I know you're saying they breached the restrictive covenants, but what's the actual claim?
The actual
action.
Yeah, so the actual claim is, and what these line of cases, whether it is Mullinax, Hamby, Lane v. Taylor, Gann versus Board of Education, is that any remote grantee can enforce the restrictive covenants on any other remote grantee. And in this case, that contract between landowners, because that's what it becomes, a mutual contract between landowners for the benefit of the development and subsequent and future landowners, is enforceable as a contract in that the remedies are spelled out within those restrictive covenants. The remedy in this restrictive covenant is injunctive relief. And so that's why we asked for injunctive relief. When Mr. Harrison was referring to the second or the main entrance, ingress and egress for this commercial development on Andrew Johnson Highway, they added a red light. The city, the Department of Transportation, because it's a highway, added a red light that controls traffic flow in and out of this commercial development onto Andrew Johnson Highway to address that traffic flow. So the argument that it would be dangerous or something along those lines, that was addressed by adding a traffic light, which happens to be super close to an existing traffic light that was already at that
Council,
roadway.
in your remaining time, will
Yes.
you address the issue of failure to cite in the record the error? And also, I would like to know what about the issue of failure to present proof of damages? Could you?
Okay, Your Honor. So as far as failure to prevent proof of damages, our clients are of very limited means. As a matter of fact, I was going to mention this, they don't speak English as a first language. And so the ability to come up and hire the experts that you would need to prove those damages was prohibitive. However, we still believe that the remedy under the law is that injunctive relief. And as far as Ms. Carroll's argument with regard to citing to the record, those were cited to in the facts part of the brief. If they were not cited to in the argument, I know that there is a lot of reference to the actual order that the judge signed. And so we feel that it's pretty clear where that argument is coming from, because we're not relying on facts, but rather the facts that the trial court found and the application of the law to that finding. We're not here to dispute the facts, Your Honor.
Thank you very much.
Thank you.
There's nothing further. I want to thank the attorneys and parties for presenting this case to us. Your case has now been submitted to the panel, and you received our opinion in a due course of time. Thank you very much, and the attorneys may be excused at this time.
Thank you.
Thank you, Your Honors.
This honorable court is now in recess until 11:30 a.m.
Thank you, Mr. Clerk.